And a very good morning to you. It's John Fradgley from the Bell Legal Group, back with you for another program of The Law and You this Tuesday morning. As always, your opportunity to get free legal advice between now and 9:30. That's 10:30 Tweed Coast time. All we want you to do is get on that telephone. 55208888 is the number. That's 55208888. And if you're south of the Tweed River, don't forget to put 07 in front of the number. Or you can send us an email at talkback@4crb.com. That's talkback@4crb. But we have someone who's been waiting very patiently for some time, and it's my pleasure to say good morning to Gavin. Hi, Gavin. How are you today?
Oh, good, thank you. And yourself?
Very well indeed. How can we help you today?
I hope you can, of course. I have a story which I'll just start at the beginning. I can fill you in. My mother and my father, they were divorced about 40 years ago. Mm-hmm. My father took everything, and my mother got nothing. She didn't pass the will. My dad and my mother remarried. My mother has passed away, and my father, he passed away about 15 years ago. My stepmother got everything except for I got 5,000 in his will. Mm-hmm. Yesterday I got a phone call from my cousin saying that her brother, that's my stepmother's brother, had let him know that my stepmother had passed away. Mm-hmm. It was on the 3rd of May, actually. Mm-hmm. Didn't even get to the funeral, nothing like that. So anyway, my purpose of ringing is that I don't know what was in her will. I don't know what the contents were, but I believe I would say that she left everything to her brother. Mm-hmm. She actually went from Queensland down to live with him in a country town. So
whereabouts?
Dubbo.
Right. Okay.
Yeah. So she was living in Brisbane. Anyway, so taken 6 months to let us know. Anyway, I spoke to her last time on the 25th of April. She passed the 3rd of May. So we've been in contact all through the years. Not greatly, but Christmas cards, ring up a couple of times a year, see how she's going and all that sort of thing.
Yes.
Now, do I have a right to find some part of the will? Or as
a stepchild you do, and Gavin, given that the length of time that has passed, I would strongly recommend that you get legal advice in relation to this fairly quickly. What part of the Gold Coast do you live?
I don't live in the Gold Coast. I'm actually in the southern part of Brisbane area.
Right, okay.
All right. Yeah.
Right. Do you have a lawyer that you normally deal with?
No, I don't. Now, someone said maybe it would be best to go to someone, say, Tweed Heads or something like in New South Wales. Would that be
it would certainly be advisable to consult someone who's familiar with New South Wales law, that's for sure. So if there are no practitioners immediately available around where you live, then it might be advisable to consult someone either in Coolangatta or Tweed Heads in relation to it.
Right, that sounds...
But I would certainly be suggesting that you act fairly quickly because in New South Wales, I think from memory, the statute of limitations is 12 months. Not the statute of limitations, the time frame to bring a claim is 12 months from date of death. But there is provision that the executor can distribute the estate earlier by giving a notification or by publishing a notice that they're going to make a distribution. So I think the sooner that you have a search made to see whether probate of your stepmother's will has been taken out and what steps have been taken so that you can get notice that you intend to make a claim, even if you decide not to make a claim, you need to get notice in as quickly as you possibly can, because otherwise you very well may find that you've lost your rights. So I would strongly recommend that you get advice in relation to the matter as soon as possible.
Well, thank you very much. That's what I was wanting to know. So, okay, then I'll get going. I'll get onto a solicitor in New South Wales.
Yes, and I would suggest that you get the first thing that they need to do is do a search, which if you're computer literate, you may be able to do yourself. You can actually do a search in the New South Wales Supreme Court Registry in the name of your mother to see what claims, if any, what documentation, if any, has been lodged. So that would certainly be a first step, but I would certainly I would certainly be moving very promptly in relation to the matter, given the time that's passed since your stepmother passed away.
Well, thank you very much indeed, and appreciate your effort and time.
No trouble at all, Gavin. All the very best. And the time on 4CRB is 11 minutes past 9. This is the Law and You. The phone number 55208888. That number again, 55208888, if you have a question or a query. Just something that I might mention, which is not really a legal issue, but many of our listeners, I'm sure, would be interested to know. The annual general meeting for the Gold Coast Christian and Community Broadcasting Association Limited, which of course is the owner and operator of the not-for-profit radio station 4CRB, was held yesterday afternoon here at the studios at 4CRB. And after involvement since the very first idea of 4CRB was raised, Hilton Redding has decided to retire from the board of 4CRB. And at the annual general meeting yesterday, it was unanimously resolved that Hilton should be appointed as the very first patron of 4CRB. So it was a wonderful afternoon, and especially that Hilton was able to be here and to be present when that honour was conferred upon him. So I'm sure many of our listeners out there would be very familiar with Hilton. It certainly doesn't mean that he has retired completely from involvement with the station. He certainly will still be around and conducting interviews from time to time, but certainly a fitting tribute, and the congratulations of the whole board, all here at 4CRB, and I'm sure the listening audience of 4CRB also goes out to Hilton for all of the years that he's contributed to this station, and for the fitting tribute that has been bestowed upon him in being appointed as the first patron of 4CRB. We'll be back after this word from our sponsor.
What makes Aveo, the Domain Country Club retirement community in Ashmore, a great place to live? Is it that friends and family are always welcome to visit? Perhaps it's the great range of activities and facilities where new friendships are made. Maybe it's because care and support is always on hand. To come and see Aveo, the Domain Country Club for yourself, simply call 132836 or visit aveo.com.au.
Our sponsor.
Finding getting out and about difficult? Our sponsor, Summit Mobility, has the solution. Located in Helensvale, Ian Baker Finch and the team at Golf Cars International have expanded their 10-year golf cart business to bring you Summit Mobility scooters. Summit Mobility will take you where you need to go at a great price. Located at 20 Kingston Drive, Helensvale, or call on 552-99499. First 10 customers will receive a $100 discount. Call 552-99499 now.
And this is the Law and You on 4CRB, our telephone number 55208888. We presently have no callers online, so if you have a question or a query for the Law and You this morning, get on that telephone straight away. 55208888 is the number. A little while back, I had a call from someone who had one of their children experiencing difficulty with a new vehicle that had been purchased, and they had been taking the vehicle back constantly to the dealer with problems, and they were ringing to query what rights they had in relation to the vehicle. And I pointed out at that time that under the Australian consumer law, that if you do purchase a new vehicle and the car turns out to be what we might commonly refer to as a lemon, then you do have a right to either get a full refund or alternatively to have a new vehicle provided to you. And it's interesting to see that the ACCC is presently in the process of taking Mazda to court in relation to this very same issue, where various people purchased certain vehicles which had major faults. One of them, which I found astounding, was where the vehicle was actually off the road for 4 months out of the first 6 months of its life or its ownership, and I found it quite astounding. And basically the ACCC has said that the way that Mazda has dealt with this has not been appropriate because that rather than allowing people to exercise their rights, they had tried to push them into other forms of settlement which fell short of the rights that they enjoyed under the Australian consumer law. So it's very good to see that the ACCC are certainly showing their teeth in relation to matters like this and ensuring the protection of consumers. But enough of that. We have John online. Good morning, John. How are you today?
Good, thanks.
How can we help you today?
I've got a general question around wills. With regard to the last call, I didn't hear all of the accounts, but the question is around challenging a will. A lawyer in passing had mentioned to me, if you have no legal standing, then you cannot really challenge a will. So I'm just wondering what this term legal standing means. Like, in the context of, let's say, a parent, the estate goes down to the children, then the grandchildren, if there's any. Let's suppose there are grandchildren who challenge the will and say, I want a piece of that. The lawyer sort of explained to me that they would not have legal standing because there's others that precede them. Is that correct?
Yes,
or how
it is correct. So basically, it varies slightly from state to state, but in Queensland, you need to be the spouse or partner of the deceased. You need to be a child of the deceased, and that includes a stepchild. Or you need to be someone who was financially dependent upon the deceased at the time of death. So unless you fall into those categories, you don't have any legal standing, and certainly unless a grandchild fell into the last category where they were financially dependent upon their grandparents. For example, if they were living with the grandparents in their home and the grandparents were supporting them, then they certainly would not have legal standing to bring a claim. So that's what your lawyer friend was meaning when he said that a person must have legal standing in order to bring a claim.
Okay, now, if there's any history there of dependency and favouritism for a grandchild, let's say, does that have any bearing?
No, I mean, if you've got a grandchild who's been a favourite of a grandfather or grandmother, and they've, perhaps bought them a car, or they gave them money for a holiday or something like that, that doesn't create a situation where you could say that they're financially dependent, and therefore that doesn't bring up any greater right or bring up any right at all. So they would still not be regarded as someone who could bring a claim in Queensland.
Okay, now let's just say they pulled the strings, and as I heard with your last caller, they file a case. Can they slow down proceedings? Can they put a spanner in the works? What could they do, even though the end result will be that they get nowhere?
Well, they'd be very unwise to do that, because they may face an order for costs against them for issuing proceedings where it is clear that they have no legal standing. So you would be very unwise to attempt to do that, because you could find yourself with a substantial order for costs against you because of the action that you've taken. All right, then?
Thank you very much.
Okay,
you
John.
answered my questions succinctly. Thank you.
All the best. Bye now. Time on 4CRB, just coming up to 20 minutes past 9. That's, of course, past 10 on the Tweed, as we say good morning to David. G'day, David. How are you today?
Good, thanks.
How can we help?
I just wondered my rights in... I was parked in a shopping centre car park, and a storm came through and collected all these trolleys with the wind, and 3 of them went into my car and dented it quite substantially. And I did ask the shopping centre, but they've just ignored me. They told me to send a quote in, which I did that, but no, they just, I ring them and they just keep telling me it takes a long time. But this is 6 months. So
Right, okay. So you're not wanting... what's the value of the damage, David?
just under $1,000.
All right, and what's your excess on your insurance?
No, this car's not insured.
Oh, the vehicle's not insured, okay. Right, well, look, it's a very difficult one. Most shopping centres have signs which say that, they're not responsible for any damage that's caused to your vehicle whilst it's in the shopping centre. That obviously excludes clear negligence. It very well may be that the question would be whether the shopping centre can be held liable for not ensuring that the trolleys had been collected and put back into the trolley bay, because people, unfortunately, as you would well see, just simply leave shopping trolleys strewn all over the car park. And it's the same as the claim some years ago when people were trying to claim for when they fell over in the fruit and veggies section of the of a supermarket and on a banana skin or on a grape or something of that nature. And the courts eventually started to hold that it wasn't reasonable for the shopping centre to have someone standing there 24/7 watching for these things to happen. But as long as they had a reasonable system in place where people went through on a fairly regular basis and checked, then they could not be held liable. And I suspect the situation you're facing, David, may be a little bit the same, because the storm very well may be regarded as an act of God, and therefore the damage that came from the trolleys was just a consequence of the storm. And so I think unless the shopping centre is prepared to do something for you, I think you might be fairly hard-pressed to pursue that against them.
Okay. It would have been nice for them to tell me that from the get-go.
Yes, it is a bit of a shame if they just string you along. But look, I would keep pushing them and maybe just ring them and say, look, I just want an answer one way or the other. Are you going to do something about this, or are you not? And who can I speak to sort it out? All right then.
Okay.
All
Thanks
the very
much.
best. Bye now. Time on 4CRB, 23 minutes past 9 past 10 on the tweet as we say good morning to Norma. G'day, Norma. How are you? Norma, hello.
Talking to me, is that you, John?
It is indeed. How can I help you today?
Oh, look, I'm just asking, how long does it take for the probate to come through in Queensland?
Presently,
how long do you have to wait?
Well, you've got to wait probably about 2 weeks to get a death certificate. There's a 14-day advertising period, but that can be commenced before the death certificate comes through. And at the present time, probates are taking probably about 6 weeks. So I would say that you could say if it was all done very, very promptly, you would be looking at 8 to 10 weeks.
8 to 10? Oh, okay, because I'm speaking to my daughter who's my executor, and they've got to wait. See, the money's all frozen, so she's got to find money for things. So
yes. Well, a lot of things.
What do you think?
A lot of things will be paid. For example, a bank will pay the funeral account without the need for probate. They'll also pay things like the insurance premium on your home, or most banks will. They'll pay the rates on the property, things like that. The banks will pay. What they won't do is release money to the executors, though, for anything until the probate is through.
And then you'd see your solicitor to...
Yes, well, what you should do is see the solicitor as soon as possible after your passing to get it all underway. Yes.
Yes.
All right then.
So about 8 weeks.
About 8 weeks.
Now, what do they actually cover? They cover the funeral.
Yes, well, most banks will pay. Well, certainly all banks, to my knowledge, will pay the funeral account. And our experience has been that many of the banks will pay the rates on a property, on the home.
I don't have that.
Okay.
But I do have. I'm in an over 50s village. So you have your monthly money, to live here.
Yes, I'm not sure whether they'll pay that or not. If that's on an automatic debit, then it may be paid until the bank is notified of your passing.
Oh, okay.
But even if it's not, most of those over 50 villages will wait until funds are available. So that's not a huge problem.
So they will take it out of the estate.
Yes, that's right.
Oh, good, John.
All right then.
Yes.
Okay, Norma. Thanks very much for your call.
Thank you very much.
Bye now. And it's 25 and a half minutes past 9, past 10, as we say hello to John. G'day, John. How are you? John, are you there?
Hi, yes. John,
How can we help?
just a quick question.
Sure.
My daughter and her partner split up, and he summons her to the federal court a month ago for visiting hours, and the court arranged visiting hours for him to have a 2.5-year-old kid visiting him every holiday for 5 days.
Mm-hmm.
And that was all set by the court.
Mm-hmm.
No other visiting hours.
Mm-hmm.
Can he change his mind and demand that the kid comes any other time to him?
Well, not without the order of the court being varied. So
Okay,
if he
I
wants to
thought
change
so.
those hours, he would have to go back to the court and ask for a change in the hours.
Yeah.
Hmm.
Why I'm asking is that he want to change his Christmas 5 days, that the kid, the 2.5-year-old kid, go and visit him on Christmas. He wants to change it to 10 days in January.
Right. Well, again, as I say, unless he and your daughter can agree, he would have to go back to the court for an order in relation to that.
Yeah. Yeah.
All right, then.
What is the relation about the 2.5-year kid? Can she live so long without a mum?
Well, that's up to the court to determine whether the arrangements are adequate and whether the father is fit and proper to be able to look after the child for that period of time.
Oh, okay.
Okay, so
Thank
that's
you
up
so
to
much,
the evidence
John.
that is given to the court to determine whether the court is satisfied that those arrangements for the child are satisfactory, and that's the issue that is paramount in the court's mind. All right, then?
Yeah. Thank you so much,
John.
for your help.
All the very best. 27 and a half minutes past 9, past 10 on the tweed as we say hello to Dana. G'day, Dana. How are you?
Good morning.
How are you, Dana? How can we help?
Is this John?
It is indeed.
Thank you. John, my husband, somebody owes him money, but he passed away now. The borrowed money passed away. Can you claim some of to his estate or what?
So someone who owed your husband money has passed away. Is that what you're saying?
Yes.
Well, certainly that debt is a debt of the estate. So if the deceased person has assets that can satisfy that debt, then that debt will stand in line to be paid according to its priority. So obviously things like a mortgage over the deceased home, which is a secured debt, would be paid first, but then all other debts must be paid before the estate is distributed to any beneficiaries under the will.
Okay.
All right.
Thank you. Because he sent that the message, I owe you money, you know? He sent that one. So, can you bring down? What can you do? What can you do?
Well, you'd have to notify the executor of the will that you're owed that money, so that the executor is on notice that there is a claim.
Okay.
All right then.
Thank you.
Okay, Donna. Thank you very much.
Bye-bye.
And the time is just coming up to 29 minutes past 9. We've still got Barry online. Barry, if you could just wait, we'll take that call offline because we're quickly pushing up to the news that's coming up very shortly. This is John Fradgley from the Bell Legal Group. Thank you to all those people who've called in today to make for such an interesting program. I'll, of course, look forward to being back with you again next week when The Law and You will continue. But until then, as always, it's goodbye and God bless.